Good evening. So basically, this course is going to be running on Tuesdays and Thursdays at 7 p.m. Taraq sir will be starting actual course content, that is the breakdown of the NDPS Act bit by bit over the next few weeks on Tuesdays and Thursdays. Towards the end, I will start weaving in the forensic analysis that takes place as far as NDPS cases are concerned. So we get a little technical. We'll talk a little bit about the tests that are done at two levels, at screening level and at instrumentation level. And then we will wrap up the entire program by an interaction between the two of us, where we'll do it like last time with the POXO program, where we talked a little bit in the form of expert versus lawyer. And that will wrap up the program. Along the way, constantly we will be open to questions, clarifications, and so we'll be sharing relevant judgments as well. So with that, I'd just like to wrap up and remind you that this is part of the deconstructing series. We have a lot of other programs where we've constantly tried to blend the forensics with the law so that we can utilize the forensics better in a court of law. So with that, I'll hand over to Taraq sir. We're really privileged to have him with us. He's a veteran criminal lawyer specializing in the NDPS Act. For those of you who did not meet him on Tuesday, he has over 25 years of experience. And recently, some of his notable appearances have been in the landmark cases of Ria Chakrabarti, Aryan Khan, Nawab Malik, and the Arman Kohli case. So with that, sir, welcome. And you can turn your mic on. I will turn mine off.
Thank you. Good evening, everybody. Yes, on Tuesday we spoke about those two cases that I discussed with you, and what we spoke about was mainly cases that take place at the airport. Today we'll speak about courier cases, which I think I chose the topic to talk about in view of the fact that this is one aspect which could affect any of us in our daily lives. The police cases, which are normally made at the police station level, as well as by the specialized agencies that have been created by the state government to handle this menace of narcotics, that is the anti-narcotic cell. And also regarding cases that are made at the ports. You see, our ports are seaports, which are very vulnerable to clandestine smuggling of narcotics. Of late, you must have seen and read in the papers the number of cases that have been made of heroin that has been coming in from Afghanistan and Iran. And there have been a flood of cases. About 6 of them have been handling, which complaints have been filed in the Panvel court in view of the fact that the seizure has been made at the Nhava Seva port. Sorry, that being the jurisdiction. But I'd like to start off talking about the courier cases. This is one aspect where even on the last occasion, I had informed everybody that, you see, your KYC documents, you see, they are such innocuous documents that we use every day, and we hand it over to people without realizing the importance of the fact that these documents are susceptible to misuse. I mean, we have photocopies of these documents almost every day. You go to a Xerox center and take copies of it. And there have been cases where some of the personnel who are working in these photocopy centers, they have been misusing these KYC documents. What happens is this: you give your copies, you either if you check in a hotel or when you get these Xerox copies, the copies of your KYC documents are kept with them. There will be one copy that will be renewed innocuously, which you will not even know. You don't realize that a copy is there. And that document is used for the purpose of either importing consignments or exporting consignments. Now, as you know that charas as well as the marijuana has been legalized in most of the Western world. There are about almost 40 countries that have legalized it. And what is happening is that it is leading to a flood of kids. When I say kids, I mean Most of the accused persons who have been arrested in these matters are below 25 years of age, who are importing these consignments on the basis of KYC documents of their friends, acquaintances, their servants, their family members, without them knowing that their documents are being used. Now, you may have a friend, for example, in the US, who will pack up 500 grams of grass and send it to you to India in a normal courier service or in a postal parcel. When the packet lands here, your name is mentioned there as the receiver. Your KYC document has been affixed on that particular parcel to show that you are the receiver. Now, most of the enforcement agencies, what they will do is, the moment they detect this kind of parcels which are suspicious, or if they think that there is something clandestine going on, they will make sure that that parcel is received by you. They will do it in such manner. First, they may send somebody in the disguise of a postman to your house, and they will say, there is a money order for you. Now, they ask your name, you say, yes, it's me. They'll say, there's a money order for you. So the initial reaction of yours is that, who sent me a money order? I mean, I was not expecting something. But the idea is to ascertain your identity. The moment they realize that the address is right and you are the person who's going to receive it, immediately thereafter you are subject to an absolute torture, wherein you don't know what is the nature of the parcel. You are completely at sea. You are taken by the customs or the police to their office, and they start investigating. The most vital aspect here is this, that you are clueless. You do not know who has misused your KYC documents. You do not know who is the sender. So at such a point of time, imagine yourself in that shoe. You are being grilled by an officer saying that there is an import consignment. You have imported contraband from so-and-so country, and there is contraband in that particular parcel. First reaction of yours will obviously be, sir, I don't know. Now, the moment you say, I don't know, there is a heaps of questions that are going to come at you. Probably half a dozen officers are going to come at you. And at that particular point of time, you have absolutely no idea as to who is the person who has stabbed you in your back. And believe me, there are cases which I have recently appeared in. When I say recently, I mean in the last 2 months, where there is a brother and sister team who has been arrested because the sister did not know that her own brother had imported a consignment of ganja from the US. The packet came in the name of the sister, and when she went to the office of the customs, she repeatedly said, I do not know, my KYC documents have been misused. Now, imagine yourself and place yourself in the shoes of the officer in such times. Because at such point of time, then that is the way you analyze as to how the enforcement agencies work. Now, the moment you say that I do not know who's done it, the entire onus then comes on you. If that man, that is the officer, cannot find a lead to pinpoint the actual person who is the importer, you are the one who is going to be arrested, prima facie. Unfortunately, this is the way it works with our enforcement agencies. If there is a seizure which has been made, there has to be an arrest to show that there is somebody behind it. Otherwise, it goes in as an unclaimed seizure. The moment it goes in as an unclaimed seizure, the department looks suspiciously at the officer himself. How is it unclaimed? Why is it unclaimed? You did not do your job properly. You should have done your surveillance before you arrested the person, so on and so forth. So invariably, what he is going to do is, he is going to arrest you. Now, if the contraband is small quantity, less than commercial quantity, good for you, there is a chance for bail. But if the contraband is commercial quantity, then I'm sorry, you'll be looking at a very long time in prison for absolutely doing nothing. There is a very classic case which we had fought in the year 2007. There was a British national, Barry Halsey, who had come to Goa on a holiday. Now it was Christmas time, and he wanted to send some Christmas presents to his family back in London. So his KYC documents he had given to a friend. He gave a copy of his passport. He gave a copy of his British license. And those documents he gave to this is one of his friend. I don't recollect his name, but he gave to his friend for the purpose of posting some gifts back to London. That man misused his KYC documents, misused the Xerox copy of his passport, and what he sent to London was in fact alprazolam tablets. Now, those alprazolam tablets were intercepted at the customs inspection counter at Mumbai, because each of if you send parcels to the foreign country through the postal services, we have a customs counter here in Mumbai, and I think there are designated customs counters in the western region. So the moment you post that parcel, it comes to Mumbai, and thereafter a customs check, and then it is sent away. Now, for the purposes of posting a parcel abroad through the postal authorities, you have to sign a document as a customs declaration. So he had signed the customs declaration, he had his KYC documents on it, and the man did not know anything about the contents of that parcel. He was at that point of time allowed to go because the enforcement agencies did not know who he was. The first time he slipped back to Britain. But then he came back to the country once again for a holiday. The moment he landed in India, after a period of almost 6 months of that parcel being intercepted, he was arrested by the customs. Now, during the course of the trial, the officers had recorded the statement of the postal authorities. They recorded the statement of the postal attendant who had received the parcel. They recorded the statement of the attendant who had issued the postal receipt, showing that the parcel was booked by the accused person himself. Now, the only reason being, he had signed all those documents. Now, in a case of this nature, during the course of the trial, it becomes very difficult to get out of it. The reason being, you have admitted your signatures. Your signature is compared with your signatures on the passport. They have taken specimen signatures of yours during the course of investigation. They have sent it to the handwriting expert. The evidence that is produced in the court, prima facie, would establish the fact that you are the one who has sent the parcel. At least the documents overwhelmingly point that out. So therefore, here we have a scenario of almost one case where there is an import, where somebody sends it on your name. And the second is where on your documents, somebody has made an attempt to export the consignment. Now, in both these scenarios, you see the person whose documents are actually used does not know about the fact that who is the person behind it. Now, in these kind of cases, what happens is that the enforcement agencies would lay a very heavy emphasis on the fact that you are the one whose KYC documents are found. You are the one who has signed it. Therefore, according to the law, there is a presumption against you. Now, how do you rebut this presumption? And in cases like this, what is the nature of defense that one can pursue during the course of the trial? The only defense in matters of this nature is the point of identification. When the parcel is being received in the country, you see, there is a little bit of a scope where you can cross-examine witnesses and point out regarding the factum of your KYC documents being misused. But if there is an export, then all your documents with your signatures are produced in the court as evidence, and you cannot get out of it in view of the overwhelming evidence that the prosecution produces in the court of law to show that you were actually the one who was the sender of that particular parcel. Now, in cases of this nature, this Mr. Barry Halsey versus the Union of India is a matter where the accused was convicted. And he was convicted for about, I think, 20 years by his honor judge, Bilo Lekar, as he then was. And we argued the appeal before the Honorable High Court, and it came up before Her Ladyship Shadna Jadhav. Now, in this case, what the prosecution had failed to do was, they did not produce his original passport in the court. It was a lapse that the prosecutor then who was appearing had committed in view of the fact that he was confident that there was so much overwhelming evidence against the accused person. The passport which was taken by the officers during the course of investigation which was in a sealed cover and which was deposited by the officers in the godown, it did not occur to him to produce that passport. Now, during the course of the trial, when I was making my submissions before the court, and I pointed out to the court, sir, when a foreigner comes into the country, the only prima facie evidence to show his identification, which everybody relies upon, is the passport. The signatures which appear on this particular document for the purpose of comparison, the best available evidence that the prosecution can produce before the court is his passport. By producing Xerox copies of the passport in the absence of the original and no application to lead secondary evidence, my submission to the court was that those signatures which appear on that particular document may be mine, but during the entire course of the trial, what had happened was none of the officers had deposed regarding that signature itself. In view of the fact that they had submitted that entire document in the form of the customs declaration before the court, and they were happy about the fact that this is a document that we are producing. It bears the signature of the accused person. When the prosecution closed its case, I realized this particular fact, and we decided to examine the accused himself as a witness. I said, you have to examine yourself as a defense witness because now we need to rebut this presumption, and you deny the fact that this document bears your signatures. There is no opinion from anybody to show that this signature which appears on this particular slip, that is the customs declaration, is compared with any signature of the accused person in the form of any authentic document. What they had done was, the statement which the accused had recorded, which the officers had recorded then, were that I have given this particular receipts to my friend. I had signed these receipts, but I had asked him to send Christmas gifts. I had given him Christmas gifts from Goa to send. I do not know anything about the alprazolam that was in it. Now, this is a very classic case where you admit the fact that I have signed these documents. You admit the fact that I did send this particular parcel, but you deny knowledge of the fact that it contained narcotics. So in such a situation, what happens is the only nexus that the prosecution can establish to show that you had knowledge of that particular parcel was to show that somebody has identified me, either purchasing those strips of alprazolam that were found there, seen me with those strips. I was at the post office with this particular box in my hand, and thereafter I gave it to the postal attendant for the purposes of posting. In all these three aspects, when I analyzed the matter, I thought that this is a serious flaw because otherwise it was a foolproof case. So therefore, when we examined Barry in the box, we chose a particular defense. He stated on oath that, sir, indeed, I was the one who gave this particular parcel to a friend to post, but I did not sign on that declaration that is there. It was my friend who forged my signatures. I gave him that particular parcel to post, but I did not give him the alprazolam. The alprazolam was put by him. And what was very important was the address to which the parcel was addressed in London was not the address of the accused person. That was an aspect. If we took the defense that this particular parcel was destined to any of the residences that belong to me, then perhaps the prosecution would have an upper hand in showing that, no, sir, it was me who had booked the parcel. It was the residence, my residential address in London, which shows that the place belongs to me, and I was the ultimate receiver of that particular parcel. And the third most important aspect was that if I indeed did send the parcel and I did not receive it there because you intercepted it in Bombay, and I knew about the fact that there was contraband in it, I wouldn't come back to India for the purposes of a holiday. So when we examined Barry in the box and he was cross-examined, there was only one aspect that came out during the course of the cross-examination, and that was the prosecution then realized that the passport has to be exhibited in the court. So at the fact stage of the trial, during the course of final arguments, the prosecution tendered the passport in the court and pointed out, sir, all throughout we have not tendered the passport, but now we are tendering the passport. And therefore you can compare the signatures of the passport and the signatures on the traveling documents and ascertain whether it is indeed the signatures of the accused person or not. The Honorable Sessions Court decided against me. The learned judge admitted that passport in the course of the trial. He read into that passport. My submissions were, sir, you are admitting a passport in evidence without giving me a right to cross-examine. That seriously prejudices my defense. If at all you relied upon this particular document, you ought to have submitted it through your first particular witness or through the investigating officer who recovered that particular contraband. And in that event, what has happened is that you have allowed me to disclose my defense, and at the fag end of the trial, to thwart my defense, you have produced this particular passport. The Sessions Court decided against me. Now, when the matter came to the High Court, the entire case was based on this one particular submission as to whether my right to cross-examination had been prejudiced in view of the fact that a vital document like the passport was suppressed by the prosecution throughout the trial. Now, our fundamental principle of criminal jurisprudence is that any evidence that has to be accepted in a court of law has to be subject to cross-examination. The moment an accused is denied the right to cross-examine, that is a serious flaw. If you see throughout the trial, and if you see judgments of the various courts, when in appeal, you will always find some observation by the appellate court on the nature of cross-examination. Either the court will say that in the cross-examination, there is an admission on the part of the witness, which benefit ought to go to the accused, or the appellate court will observe that there is no cross-examination to this particular aspect, and a fact that is not denied by the accused, there is a presumption that there is an admission. So these are two very vital aspects. So when the matter came up before the Honorable High Court, the Honorable High Court was pleased to observe that throughout the trial, if a document of this nature, wherein the trial court has based its entire decision to convict the accused persons, lies squarely on the aspect of admitting the signatures and coming to the conclusion that it is the accused who sent the parcel on the basis of the signature appearing on the passport, then I ought to have been given a right to cross-examination at the initial stage. That not being done, the High Court set aside the order of the lower court, and the man was acquitted after a period of 9 years. So you imagine the man remaining in custody for 9 years for something that he had not done. Now, of late, if you see in the newspapers, there are a lot of cases where there are kids, as I said, when I use kids, I mean below 25, who have either in this euphoria of wanting to smoke imported stuff, because as Indians, we are still crazy about foreign-based stuff. And if that is being carried out to marijuana and the strains, as they call it, that are grown and processed in the US in particular. These are the other countries from where a lot of contraband comes in, of course, is Holland, as we know, because everything is open there. So when one of their friends who chooses to send this contraband to our country, and when it is intercepted either at the postal office or by the customs at the customs ports, in view of the fact that it comes through courier parcels and is subject to customs examination, the officers will make that attempt to nail it on the person in whose name the parcel comes. Now, if any of us at any given point of time ever falls in this situation, please be alive to the fact that you may not be the person who has actually ordered that parcel. And if it has come in your name and you are not aware of it, do not accept it. Be very clear, be very firm, exactly at that point of time. I'll tell you a very sad case of a music teacher. There was a music teacher at Worli, and he had a number of students. He used to teach the guitar to a number of students who would come to his residence. Now, one of his students was obviously notorious. He gave his teacher's address. I mean, you will not believe it. He gave his teacher's address for the purpose of receiving this parcel. And he spoke to the postman who was delivering letters and parcels at that one particular address. He told him, Sir is very busy and he does not normally like to open the door and take parcels. If you see any parcel, this is my number. Call me. I will take the parcel and I will authorize. I'm authorized by Sir to sign on this particular document. That particular parcel was intercepted by the customs. He imported about 16 such consignments without being detected. The 17th time, it was intercepted by the customs, and they asked the postal authorities to send a dummy postman for the purposes of delivering it to this man's residence. So the regular postman who was going there was on that day told, you do not go there because there is an operation going on. So his suspicion arose. He said, like, why am I not supposed to go there? It is my area. It is my building. I've been delivering parcels and letters here for about 6-7 months. So then he was told, no, this music teacher is somebody who is indulging in narcotics, where there is an operation. So you will not go on that day. There will be somebody who's from the customs department who will be dressed as a postman. He will go and deliver this particular parcel. So the customs man goes there. The customs officer disguises himself as a postman. He goes there. He delivers the parcel. He asks the name of the teacher. At that particular point of time, once again, this boy goes there, says, yes, there's a parcel. Sir has authorized me for the purpose of taking this parcel. At that point of time, the officer concerned did not realize that this boy is behind this entire racket. He still says, no, you're a student. I want to know who's your teacher. This parcel is come in his name. So I want to know who your teacher is and who is the person who is named on this particular parcel. So he says, he's my teacher. You may come and, at that point of time, the officer called the teacher and said, there's a parcel for you, sir. So his teacher says, I have not ordered for anything. I mean, what is it? So he says, no, this is contraband in it. And it has come in your name. Therefore, we need to record your statement. At that point of time, the student who was actually there realized that, oh, there is trouble brewing now. So from that point of time, he absconded. Now imagine yourself in the shoes of this teacher. What saved him was the postman. The postman came forward and said, sir, मैं ये address पे इतने parcel दिया हूँ, similar parcels coming from the US, but this sir has never signed and taken the parcel. It is always one student who comes to me and says that I have been authorized, give me the parcel. And because at each time that I go to his residence, the poor man is teaching a bunch of students. So I thought I will not disturb him and I will take that particular parcel. So throughout receiving about 16 or 17 parcels, you can imagine the teacher's state when he realized that his own student had taken him for a ride and his name was being used for the purposes of actually importing contraband ganja into the country. These kind of cases are not uncommon. And the reason why I choose to discuss this with you is these are things that can happen to anybody. You see, so be very careful of your KYC documents, be very careful of what you send and who you give your parcel to send. And be very careful if anything comes to your residence which you have not ordered. Nowadays, everything comes on Amazon, and we have so many of these websites where people shop from. But be very careful. Please instruct your family members, friends, whoever you know, to be very safe in respect of ordering and from which website. This is in respect of these courier cases, which I thought I should discuss with you. The other aspect are the cases that are made at our ports. You see, our ports are very porous. Anyone wants to, ask me any questions, I'll be open and I would like to answer those. Any doubts? Anybody wants to, know certain more details about any of this aspect?
Sir, I have received just one question in the chat box. The person wants to ask about you were speaking about that the court thwarted my defense by making me disclose my defense.
Yeah.
So what is that about? Just the legal aspect.
See, I'll tell you. You see, as a defense lawyer, whenever you are conducting a trial, as I stated, you need to choose your defense. What is the nature of your defense? When I say defense means sometimes there is overwhelming evidence against you in the form of documentary evidence which you have signed. Now, see, law is basically, in my view, just common sense. You say you place yourself in the shoes of the judge. If there is overwhelming evidence to show that you have signed those documents, then you don't deny it in the court. You go with the case of the prosecution till as far as you feel that it is not incriminating against you. So when there is a document which is produced in court which bears your signature, and you feel that it is incriminating enough to take it to a particular stage from where you need to deviate and say, for example, that when I signed this document, it was blank. It was not filled. When I signed it, I did not know the contents of the document. Because when you appreciate it on the principles of the Evidence Act, the proof of a document is the contents of that entire document. So I may sign a document at the end, but it does not mean that I have proved the contents of that document. What the court can then look into is only the fact that I have proved my signature on that document. The entire document stands, will not be proved in the court of law. So when I sign on a particular document and the witness before the court says this is signed by me, and in my opinion, the only way the prosecution could have proved the fact that it is signed by me is by producing the passport. And if the passport is not there, you see, every aspect in a court of law, if it is produced as primary evidence, the prosecution, in view of the fact that the contraband was not found in my possession, ought to have led corroborative evidence. When I dispute my signature, my signature on the passport, I could never have disputed. But my signature on this particular document, I could have disputed. So when the prosecution keeps back the passport because they have arrested me and compared the signature of my passport on that particular parcel to prima facie nail me, then in such a premise, they ought to have produced that passport to show, sir, that during the stage of investigation, the officer did come to a reasonable belief that I am indeed the signatory on that customs declaration. So if I disclose my defense at the first witness that I did not sign it, then it is open for the prosecution to close my defense by leading evidence further down to show, no, this is indeed his signature. So therefore, most lawyers, they will not disclose their defense to the first 2-3 witnesses. They will keep it to themselves. The moment the corroborative evidence starts coming in and the strength of the corroborative evidence is disclosed, on that basis, we start disclosing our defense. So that is the normal strategy in most of the trials, which I think every trial lawyer follows. So that is what I mean when you ask me to disclose my defense, and thereafter when you try and shut the doors of my defense, you bring additional evidence which you had earlier. You see, what happens is the Supreme Court has been very clear in the matters of trial now. They say that even at the stage of judgment, when the judge is about to pronounce the verdict, even at that stage, if there is evidence which is now available to the prosecution, which was not available earlier, can be produced in a court of law for the purpose of proving the charge. But if you have the evidence and you choose not to produce it, then at a subsequent stage to produce it post me disclosing my defense causes serious prejudice to me. That is what I meant.
Right, sir. Got it. Rajeshji, you have a question to ask?
So very good evening to you, sir.
Good evening, Rajesh.
Sir, in this British national case, you were saying initially he admitted there that his signatures are there.
Yes.
And subsequently, you said that you told him to enter as a defense witness on oath and say these are not my signatures. So
Yes.
this is not true.
No,
if he
I'll
has
tell you.
already, then how can he then won't it the court take an adverse inference of it that he's?
You're absolutely right. See, what you admit during the course of investigation is something that the prosecution has to prove at the time of trial. During the course of investigation, you may say anything, but the degree of proof of proving that particular aspect as a matter of fact to prove a charge which is framed against you, the degree is much higher. So what you admit during the course of an investigation, you need not admit during the course of the trial. You see, you can always say it was forcibly taken, or I did not do it, or the officer himself has created this particular document. And the onus is on the prosecution to prove that it was a signature that was voluntarily made by the accused person in the presence of independent witnesses, which ultimately led me at that particular point of time to come to the conclusion that I had committed an offense, and that reasonable belief was enough to allow me to place him under arrest. Otherwise, the arrest itself is vitiated.
Now, sir, having said so what you said, I don't remember where I was studied, but there's a doubt which is cropping up in my mind that somewhere I studied in one of the case law somewhere that the narcotic officers, they cannot be equated with the police officers. Like the statement given to the police is not admissible as evidence.
You're absolutely right.
Same status cannot be granted to the narcotic officer. So should we say that the statement which is given to a narcotics officer will be taken as evidence?
No, it was admissible,
like
sir. It is admissible. It was admissible rather till last year.
Okay.
It was admissible till last year, till Tufan Singh came into picture, the judgment of Justice Nariman, where Justice Nariman has held that all statements made under Section 67 are now inadmissible in evidence. You see, the criteria is this. Police officers, any statement made to the police officer is inadmissible, right? But customs officers, NCB officers, DRI officers, they are not police officers.
Yes.
Because they do not file a charge sheet in the court.
Correct.
Criteria in Rajkumar Karwal's case, 1991, I think it was Justice Ahmadi's judgment, wherein this matter traveled from Bombay High Court only. And the original order that was challenged was of His Lordship Justice Suresh. You see, he had held that there was an argument that the statement made to the officers of the customs and the agencies other than the police, so which should also be inadmissible in view of the fact that 67 itself, Section 67, does not authorize them to record a confession.
We're talking about 67 of NDPS?
Yes.
Okay.
So that till last year, it was held to be admissible in evidence. But now Tufan Singh has come into the picture. All statements made even to central investigating agencies are inadmissible in evidence. But I think the reason why
in such cases, you said they are not filing charges, then who files the charge sheet?
No, they file complaints. You see, there is a difference between a charge sheet and a complaint. A charge sheet is filed under 173 of the CRPC and it is filed by a police officer under Chapter 12.
Correct.
A complaint is filed under 190 of the
Correct.
CRPC, where the court takes cognizance on the basis of a written complaint. So the officers of the central investigating agencies, even today, they don't file charge sheets. They file complaints. And the admissibility of a statement, earlier on, it was admissible. But in Barry Halsey's case, it is the statement. I was not talking about the statement. I was talking about the signature. Because the statement was in my favor. He had given a statement that I had not sent the parcel. I had not sent the Alprazolam, but I had sent the parcel. You see, it was a very touch and go matter. You understand? He says, I sent this parcel, but I did not put the drug in it. You see, so it was a very limited scope where I could cross-examine a witness and try and get something in his favor. And therefore, at the fag end, I decided to say, no, the signature is also not right. Why? Because they didn't produce the passport for the purpose of corroboration. But as I said, the session just convicted it. You see, so it's just a matter of perception. You see, one court, the other court, so on and so forth. Because judges
I
also.
think in all these narcotic cases, this basically complaint is filed, no charge sheet.
No, police file charge sheets, sir. I am coming to that. I am coming to now police cases. Police cases which are made by the police, by the state police. These are all central investigating agencies. NCB, DRI, RNI, Customs. They are all appointees by the Central Board of Taxes, who are Central Board of Customs and Taxes, yes. So they are a separate class of officers. They are not police officers. Customs officer तो law enforcement करता नहीं है sir. Law enforcement police करती है. और अगर police ने smuggling भी पकड़ी, तो they don't have powers to make that seizure. They are supposed to give it to the customs, who are a special class of officers who are appointed only for the purposes of investigating offences under those offences which are classified as prohibited under that special statute. I'll explain it to you when I come to the NDPS Act. What you're asking me is very pertinent, but I'll explain this to you when I come to the Act and the powers that are conferred by statute. You see, each of these special acts have special officers, procedure of investigation, class of officers who are given special powers by statute. Up income tax, I'm sure you pay income tax. Income tax officers are a special class of officers. They are appointed under the Income Tax Act. वो वही काम करेगा, वो दूसरा काम नहीं करेगा. You see, custom officer का काम है to prevent smuggling. तो वो वही करेगा. But under the NDPS Act, under section 42, all these classes of officers have been given special powers to enforce this special act. Therefore, the difference. So the state will, state also enforces this particular act. Central investigating agencies also enforce this particular act. Excise tha, you remember excise was there in state of Maharashtra. It was a state statute, right? So we had a special class of officers who would only enforce the excise act, like that. I'll explain that to you. But as far as this matter is concerned, as I said, the only difference that I had at that point of time was to deny signature. Okay? Okay.
So I don't want to preempt this thing since you have planned things as per a schedule. But just a request, sir, when you will explain this, if you can bring touch upon this issue also. Now that you said,
I will specifically call upon you and I will touch this issue.
yes. So kind of. No, I just wanted to tell this thing because you just now said.
My pleasure.
If the police officer is seizing something or smuggled this thing, they will hand over to customs.
Yes, they don't have
My
powers
doubt
to seize.
arises here, which I'll ask you that time, that if they are handing over to the customs, then why those people are not filing charge sheet? Then it is the matter with them. Why should police be?
No, I'll tell you. For example, abhi nakabandi hoti hai Bombay mein, right? You're from Mumbai. Are you from Mumbai? From wherever you are from, I'm sure you see nakabandis on the road, police checks. Correct. Now, if I have a dicky full of gold in my car, okay, the police intercept me. The police find gold. Okay. They also realize that I'm smuggling this because it's foreign marked. The police by law can intercept you. Why? They are there to prevent a crime. But the powers to investigate is with the customs officer. You understand the marked difference? It's like when I was talking about the case at the airport, the CISF. You'll have to read these special acts, sir, to understand how powers are conferred by the special statute on a particular class of officers.
I'm aware of that.
So therefore, in such a situation where there is no power and there is a special, officers have to hand it over to the officers who are empowered to conduct a seizure as well as prosecute a particular person. I could very well explain where the gold came from. I may have a receipt of having paid the duty. But a police officer is not empowered to investigate an offense under that particular statute. But as I said, when I read 42, I'll explain this to you. Yaad se Rajesh Saab.
Thank you, sir.
Okay, okay.
Thank you, sir. Sir, I have a question. जो पहले admissible होता था पुलिस ऑफिसर्स के सामने, मतलब नार्कोटिक ऑफिसर्स के सामने statement देना, and now it is not. What was the logic behind marking that difference between police officers and narcotics?
You see that you read the judgment of Tufan Singh. Justice Nariman has basically relied upon section 53A of the NDPS Act. And the reason why he holds that those statements made to this particular class of officers is because they are conferred with powers that an officer in charge of a police station is given. What is weighed in his mind substantially is section 53A. And for that, I will have to go back right up to 1956, because that was the time when the Sea Customs Act was in the picture. And you see, an accused person is not an accused person unless and until there is a complaint filed against him and a court has taken cognizance. It's a completely different aspect that we'll go into. But the reason what weighed in the mind of the Honorable Supreme Court and Justice Nariman was section 53A of the NDPS Act, and the fact that 67 gives the power to an officer only to call for information. You see, if you see all these special statutes, if you see 108 of the Customs Act, if you see 18 of the MCOC Act, if you see 70 of the GST Act, if you see 50 of the PMLA Act, all these statements made to officers are admissible in evidence because the statute says so. That any statement made to an officer during the course of recording of a statement is admissible against him. It is can be used as a judicial proceeding. And giving a false statement you are liable for prosecution under 193 IPC, 228 IPC. So if you give a false statement to any of these officers who are of and above a gazetted rank, and if it is found that they are false, then you are even liable for prosecution. But the wordings of 67 of the NDPS Act are not on par with the wordings of these special statutes that I have just named. So if you see section 67 and you read all these sections that I have just pointed out to you, you will see a marked difference in the wordings of this section. So therefore, the Supreme Court says, no, by statute, you don't have a power to record a confession. So if you don't have power to record a confession, then that particular statement is hit by your right of silence, firstly, which is guaranteed to you under the Constitution, and the fact that the statute does not confer a special power on you for the purposes of recording a confession. You see, if a confession is something where you admit unequivocal guilt, right? Now, if you see the Evidence Act, you go from section 17 onwards. You see that it's a chapter on admission and confessions. So there is a marked difference between an admission and a confession. It's like the distance between the cup and the lip. It's right here, but the tea is not in your mouth. You get it? So, I mean, it's a vast subject. If we can talk upon it, I can go on with you for days together. But Justice Nariman has held in view of section 53A, more specifically, that it gives you the power of an officer in charge of a police station. 67 does not give you power to record a confession. Therefore, every statement that is made by an accused person before any officer under 67 is inadmissible in evidence. That is the logic behind it.
Right, sir. Got it. I think we have no more questions as of now. We can move on.
Okay, now we'll go to police cases. You see, police cases are ones that are made at the police station level and by the anti-narcotics cell in Mumbai, which is a specialized unit which deals only in narcotic cases. They will not investigate anything else. We've got 5 units in Mumbai and we have a head office at Cup Parade. We have the godown which is situated at Azad Maidan. Now, the reason why these police cases are also important is that there is, if you see the procedural aspects of what the customs and what we just discussed about, the reason why I chose to start off with this is because I think at some point of time, any of us could be affected by it. But as far as the police cases are concerned, these are cases where most of the peddlers are caught. You see, in years of practice, having made a number of allegations against the police in the court, saying you falsely implicated my client, you picked him up from the residence. But one thing I will admit is the fact that they pick up people who they know are doing business. They may not make genuine cases, but they keep a watch on a person for the maybe 6 months, 8 months. They know the person is dealing in drugs. They know that they can't find him in an actual transaction, because it is always clandestine. Then they pick up the person from his residence or wherever they find that particular person. And if they know that he's indeed indulging in large scale, then a case of commercial quantity is made out. Now, police cases, if you see most of these cases which are made by them, they will record this information that is given to them by an informant. They will record it in what is known as the information register, which is maintained at the police station, or in the station diary, which is maintained by the police station. A copy of this information is sent to the superiors for compliance of section 42. The contraband which is sealed at the spot, samples are taken, are deposited in the godown register and the godown, which is situated at Azad Maidan, where it is documented in the godown register. And after a couple of days, the samples are sent to the central investigating agencies, to the laboratories, for the purpose of analysis. And thereafter, within 180 days, if it's commercial quantity, a charge sheet is filed. Now, the police cases, if you see, most of them which are made at the police level, at the police station level, the officers have not had a stint as a specialized unit with the narcotics cell. Now, the NDPS Act is a very procedural law. Sometimes you find it very funny because you have safeguards like 42 and section 50. But then you, over a period of time, you also realize how easy it is to overcome these safeguards and prepare a document just for the purpose of producing it in the court. At the initial stages, the officers were not aware of this fact that there is a procedure, and the fact that if the procedure is not followed, it vitiates the entire trial. Earlier on, prior to 1994, before Balbir Singh came into the picture, the courts had held that non-compliance of all these provisions is not mandatory, it is directory. But post 94, when Balbir Singh came into the picture, the Supreme Court held that no, all these procedures are mandatory, but the police will follow it to the T. The only issue that I have with the police, which with the cases which are made at the police station level, is this: they have very shoddy paperwork, and that reason is twofold. The officers concerned who make the seizure are not interested in making the paperwork. You see, there is always a saying which I think I can tell you about experience. You may engage a very good lawyer, but your faith depends on his diary of that given date. If in a given day he has 15 matters, trust me, he has very little chance to devote much time to your matter. Why? Because he's keen to go and attend the other work. I shouldn't be saying it, honestly. But same is the aspect of the police station. The man who wants to go home at 8 o'clock, there is a seizure which is made at 7:30. He doesn't want to do the paperwork. Usko ghar jana hai. So he leaves it to his subordinates who do not know the procedural aspects of how to make those cases. So in police station cases which are made at the police station level, where they do not have experience of making narcotic cases, most of the time there are serious flaws. They will not deposit the samples in the godown. There will be no movement register. Their paperwork will show that they are on duty when actually they are not on duty. There are discrepancies in the station diary. In one matter, there was a case that was made out where the senior inspector of Baikala police station was taking a parade in the police station compound. There is a station diary, VIP Hazir, Sahib parade ghetat. And there is a Panchnama showing that he is making a case at Ferry Wharf. You see, so these kind of things do happen. There are a number of cases where the officer is taking a remand in the court. His name is mentioned in the court Roznama, so-and-so present with the accused person. He is taking a remand, and at the same time, his presence is showing in the Panchnama elsewhere. So these kind of hoxposes do happen only in these police cases, where the officers concerned are not much interested in the paperwork. They've made out a case, they've recovered commercial quantity, they know the courts will not grant them bail. Never mind after 5-6 years, if the man is acquitted, no problem. 3-4 saal to usko andar rakhe. That is the think tank of the police. But not so of the NCB and the custom. Their paperwork is always up to the mark and convincing enough for the learned judge to even convict people. The third part, I think what I want to discuss today is these seizures that are being made at the ports. You see, you've been reading the tons and tons of heroin that is coming in now, thanks to the Taliban being in power in Afghanistan. And unfortunately, most of the material that is used to manufacture heroin is going from India. You see, all the precursor chemicals, acetic anhydride, which is necessary for the purposes of manufacturing heroin, is being sent there. And the prepared heroin is coming into our country. I have handled 6 matters so far regarding these imports into the country. And in each of these cases, I think one of the matters was widely reported where the seizure was made by the DRI, where one of the accused person committed suicide in Taloja jail. Because he was an Indian man and he was getting cornered by the Afghan cartel while he was in custody, to such an extent that the man decided to end his life because his family members were being harassed out. But the modus operandi is this. Whatever is being used for the manufacture of heroin is being sent out from India. And unfortunately, we have people in our country who are more than willing to do it. and the import of the heroin is being done by the same cartel with a percentage of the profit that is gained in our country on the basis of sale, which accounts for the purchase of these precursor chemicals. So what is happening is this: there would be a couple of their persons from their cartel in India who try and procure these controlled substances which are used for the manufacture of heroin. Licenses are being used because there are, unfortunately, in our country, there are a number of persons who have import-export IC codes, and they hand it over to people for the purpose of misuse only for as a sum as low as 1,500 rupees. You see, I'm just reading a charge sheet, in fact, of a case where this man Himanshu Rana has been arrested, and the heroin that is recovered is methamphetamine that is recovered is 897 kgs. So yeah, 897 kgs is a lot. I mean, it could destroy an entire state, let me be honest with you. And we have a number of our youngsters who would be hooked onto this shit. But when I read the charge sheet, it was like, sometimes some of these matters give you goosebumps. The manner in which this conspiracy are hatched, 2 of their people will always be in India. And the fact that we are so vast, it is so easy for them to just go under once a matter is detected. They come here, they befriend these kind of people for these kind of sums. Ask them to go and purchase these precursor controlled substances in the market, send it back to Afghanistan. Heroin is manufactured there, and now there is a new route to import it. It's coming from Iran. You see, so the moment the heroin is rerouted into the country, it is now being sold into the open market. Now, most important here, once again, is your KYC documents. You see, you may be an importer, you may be somebody who's got a license. Your license is susceptible to misuse. You give it to somebody showing yourself as an importer. You do not know its contents. You are happy to take your 5,000, 6,000 to allow that particular consignment. Why? Because according to you, you are not somebody who is in the know-how what is being imported. You sign on all those documents as an importer. You give it to your CHA. The moment the consignment container lands into the country, your shipping company will give you the factum that you now have to submit your shipping bill to the authorities. And the fact that there is no 100% complete 100% check of these containers because of the load that is with our customs authorities. Most of the time, they come into the country without a check. It's not possible. You see, but when there is a definite information and the officers do go and search and recover these kind of huge amounts of heroin, make no mistake, it is coming through a very organized cartel. And most of the times, it comes into the country with by persons on whose names the consignment comes into. They will never be aware of the fact that what is coming in that consignment is actually heroin. They're told that some chemicals are being imported, or there's a case where the jaggery was being imported from Iran. There was a container of jaggery that was declared, but what came out of it was about 192 kgs of heroin. So if at any given point of time, when these seizures are made, it becomes very difficult for the enforcement agencies to nail it on that particular person, because the paperwork does not point out their involvement. The paperwork will show you as an importer. It is the CHA who gets caught. It is like in GST cases nowadays where the assessee is himself committing the crime, but the chartered accountants are also getting into the grind. See the number of cases where GST authorities are arresting chartered accountants. Similarly, a CHA is a custom house agent. All his role is about is to facilitate import of that particular consignment. But the moment contraband is recovered, what you are charged for is facilitating and a conspiracy charge to import contraband into the country. Why? Because you are the one who submitted the paperwork to the customs. Believe me, most of the times they do not know. I mean, nobody knows CHA is going to allow the heroin to be brought into the country in such magnitude for a paltry sum of about 30 or 40,000 rupees, which are his regular charges. But it's happening, and unfortunately, it's growing. These are the cases also that are on the rise now. And most of these cases, I'll be honest with you, it becomes very easy for us because there is no evidence against the actual importer, save and except the statement of the co-accused, or a person who says that I did not know that this contraband was to come. I was told by a particular person, I'm giving you 15,000 rupees, allow me to use your IC code. And the person who was introduced to the actual importer is also somebody third, it's a third person. You see, it's all word of mouth. You use your friend, he uses his friend, and the link, you will, the actual person who is the importer may be the third or the fourth link. So it becomes very difficult for the enforcement agencies to actually pinpoint the fact that you are the person who is concerned behind it. And by the time they realize that there is something wrong, is because the enforcement agencies detain that container for a few more days to keep a watch as to who comes to clear it. That is enough for them to be given the clue that this container is under surveillance and the main persons behind the entire import thereafter abscond or go under. So you see, these are the matters which we normally deal with. And there are a number of other matters, I mean, as I said, but these are the cases where, which are predominantly coming up in the courts, and we have to deal with these matters on an almost daily basis. Any questions, anybody? I mean, on the next session, we'll be actually going with law. I was told to discuss, cases as far as the first two sessions are concerned. But the law and the intricacies of how it is implemented, how it has to be produced in a court of law, how it has to be proved, we will be dealing with our lectures subsequently, where in each of these examples that I gave you today and on Tuesday, we will be discussing at length, and the implementation of the act and the manner in which the evidence has to be produced in court for a judge to accept it. You see, the courts will accept only aspects that are admissible in evidence. Anything that is inadmissible, the courts do not take them even on record. So therefore, the task of the officers is onerous. They have to be very careful of how the paperwork is made and the subsequent chain of custody of the samples till it reaches the CA. But our enforcement agencies are doing good work. Though I'm at loggerheads with them in the court, but as I said, as a citizen, I do support each and every move of theirs in trying to curb this menace. And my request to any of you would also be the same. If at all you come upon any officer asking you to witness, or the fact that you are a witness to a particular event, please don't say no. It's your duty to help them enforce the law and take it as an opportunity given to you to help the country. That is the way I look at it. Thank you so much. Any questions, anybody? Rajesh sir.
Thank you, sir. Sir, we do have one question from Mr. Anurag Agarwal. We have others as well, but if you would like to go ahead, we'll do. So, Anurag,
no problem.
Anurag sir wants to ask that there is a typical pattern nowadays, sir, under section 42. He has not mentioned the act. Police claims as in an informant-based report and lodges FIR even if there is no recovery in person. Thus, the alleged accused has little defense. How to deal in such cases of possible misuse of powers?
You see, 42 has nothing to do with the lodging of the FIR. 42 is a section which requires the enforcement agency to reduce the information into writing. If an officer receives an information, his job is to put it into writing and submit it to his immediate superior officer. Earlier on, it was immediately. Subsequently, there is an amendment that it should be done within 72 hours. Now, an information, most of the time, if it is received by an enforcement agency, it could be true, it could be false. Every information that is received does not work out to be true. You see, there are times that the enforcement agencies fail also. So I give an information to somebody right now saying, yes, sir, this so-and-so person is going to come with contraband below my office at 5 o'clock. That person does not turn up. So that information has failed. He will register an FIR only if there is a recovery. You see, otherwise he is not going to register an FIR.
Right, sir. Anurag, do you have a follow-up? Okay.
Thank you, buddy.
Sir, many times I have heard that the police plants, stuff on people out of the stock. So how do these cases go?
They do, but they do it to people who are doing business. I told you that. They will not pick up any innocent person and put them behind bars. That much I can tell you. Yes, they pick up people, make cases in the police station that everybody knows. It's a matter of, I mean, it's not a secret. But you see, the court and the judges are bound by the papers that are produced before them. And so are we. So you have to turn an Nelson's eye to this reality and just go ahead with what the procedural aspects and the courts and the procedure requires. But I will definitely say one thing in favor of the enforcement agencies is this: they do not arrest innocent people. There has to be something. Therefore, as I said, you have to be very careful. You could be the wrong place, wrong time, with the wrong person. You could have a close family member who's been doing these things clandestinely and you do not know. And most of the family members then come to you, say, no, I swear my husband could never have done this. My son is not like this. He's God's good man, so on and so forth. I said, no, everything that I do, I don't go and tell my father. And I'm sure half of us don't do that. You see? So the police, yes, they do make cases of this nature. But as I said, they are not cases where they catch people who are totally innocent. आपका कुछ ना कुछ connection होगा. अभी, for example, my CDRs are available with every drug peddler that is arrested. And there are so many times that I know that fact, but the officers concerned, when they see my number, they know it is me. And that he must have followed up with me for somebody in jail or so on and so forth. But if they find your CDR on it, which is consistently over a period of 6 months, they will definitely call you. आप बोल सकते सर मेरा तो दोस्त है मैं दिन में उसे 6 टाइम बात करता हूँ. No, but for the officer, you are somebody concerned with the peddling. He wants to understand the fact that you are not concerned with the actual recovery of contraband. So make sure you also ascertain the company that you keep and who you are with. As I said, I mean, I will talk in favor of the enforcement agencies here.
Right.
Because yes, everybody points a finger at them, but make no mistake, they work under onerous conditions, boss.
Right, sir. Correct. Sir, another question from Deepak Tongli. He wants to ask, how are drug peddlers charged? They don't consume, but they are involved in the crime.
If you're found in possession, no problem. If you're found in possession, you're charged for possession. They don't consume it themselves. If you're only a consumer, then you're charged for consumption, which is a much lesser charge. But the peddler who is found in possession of the 3 quantities that quantify under the NDPS Act, you're charged according to that: small quantity, intermediate quantity, and commercial quantity. So they are charged according to the amount of which are recovered, which is in the table of the NDPS Act.
Right, sir. Sir, another question from Kul Milan Pawar. He wants to ask, sir, what should we do to ensure our KYC information will not be misused by anyone?
See, I think you write on it where you're submitting it. You see, for example, if you're in a hotel and you have to give your license copy, the moment she takes a Xerox copy or he takes a Xerox copy, ask it back from her and write on it, this was submitted in the hotel on so and so date for the purpose of stay. And make sure it covers the printed part where your pictures are. Don't sign below, otherwise he'll just tear it off. You know what I mean?
Right, sir.
Yeah, and whenever you give your KYC documents for Xerox copying at any of these centers, be very careful. Make sure 2 copies means 2 copies. And if he's removed an extra copy, he'll try and pretend to tear it up and put it in the box. He'll fold it and put it in the box. Make sure he picks it up and he tears it to pieces.
And so sometimes do share these with the cards वगैरह वाली companies for cards, the soft copies. उसमें तो फिर
misuse is possible everywhere. And let us understand, we live in this electronic world where everybody is living through cards and banks and credit cards and so on and so forth. And your mobile phone is a dead giveaway. Make no mistake, that enforcement officer knows exactly where you are, where you're sitting, who you're talking to, when you're going to leave from here. They know everything on the basis of this one instrument, you see. So be very careful of who you talk to on your phone. And even an innocuous chat can get you into trouble. You see, in Riya Chakravarti's case, there were 36 accused persons. Out of the 36 accused persons, 20 were arrested merely because they were chatting with their friends. Let's go, let's get stoned. Yes, call this particular person. Let's do this. They had downloaded certain images from the internet on their phone. And it all got them into trouble. They are all the accused persons are from decent households. One is an architect, one is studying doctor, one is studying medicine. You see, so some other person is a businessman, one other person is a builder's son. Absolutely nothing to do with transporting contraband or even concerned with it. But yes, that chat will show something totally different. You see, you like to exaggerate. Na? आप एक ड्रिंक पिएंगे तो दोस्त को तो बोलेंगे अरे आज मैं 5 ड्रिंक पिया, I'm still standing on my legs. It's like that. You see, and that can get into trouble.
Right, sir. Answer a very naive question. जैसे आपने अभी you told that these people got stuck with the situation when the parcel was delivered to them on their doorstep. So if something of that sort happens to us and we are not very careful with our documents and everything, things get done and the thing is parceled to us. Now, when the person is standing there and we do not actually know if the parcel is for us, but it is on our names, we are obviously curious कि हमारे लिए आया तो होगा हमारे लिए. Uss time पे if we get to know that it is something wrong, we should not have got it. So how do we fend off that situation?
No, you immediately refuse to take the parcel. Tell them, and this is not mine. I didn't order it. Somebody is trying to, create evidence against me, or there is somebody who is, misusing my name and my KYC for the purpose of import. It's as simple as that. Don't sign any document to show acceptance of that particular document. The moment you refuse it, that is your conduct, which is admissible in law. You see, your conduct is always something that a court looks at. After parcel, as I said, you see, in most of these cases where accused are absconding, you know what the police do? They don't go searching for the man. Last known address पे पैसे भेजते हैं उन लोग. सर आपके नाम पे 5,000 का मनी ऑर्डर आया है. अब अगर किसी के नाम पे मनी ऑर्डर आता है और वो आदमी नहीं है तो पोस्टमैन से हम उसी को देंगे जिसके नाम पर है. तो वो जो भागते रहता है ना, पैसे आए कहां से, हाँ मैं आता हूं लेने को. Basic, every police officer does it. So the moment that money is accepted by that person, they know, okay, now this man is here. Or the relative will say, वो इधर नहीं है, मेरे चाचा के घर पे है, वो मेरे दोस्त के घर पे वहां पर है, पैसे आए. You see, it's your conduct that ultimately leads you to wherever you are in life. Let me, be very clear on that.
Right,
so
sir.
You just got to be careful on that.
Right, sir. Colonel Tandon, you have a question?
Yeah, Rajesh, sir.
Sir, regarding this KYC document, a very valid question was asked by one of the participants, which you answered it very well, sir. Should I take it that if I give my Aadhaar card for photocopy in a hotel, he takes out one copy, so should I instruct him to take 2 copies, give 1 copy to be on which, or I should sign this is for this purpose, and then take another copy?
No, whichever copy you are giving him, you sign on that this is the purpose for which I am giving this to you.
Okay.
Don't give him extra copies. नहीं, आपको जरूरत नहीं है सर. उसको जो रिकॉर्ड पे रखना है ना, उस पर आप साइन करो, and make sure he takes only 1 copy.
Fine. Now, supposingly, I'm checking out of the hotel after 12 hours or maybe 2 days or so. So, should I tell him, give me my copy that which you have?
No problem. You can keep it, but you've signed on it, no, that it is for that purpose. So, even if it is misused, your thing is there. कि I gave it to this hotel. At least you will remember कहाँ दिए थे. देखो, most of the time तो आपको याद ही नहीं रहेगा कि आपने Xerox copy कहाँ दिए थे.
Correct. Now when you said you signed across the name or the image, something you said when you
yes, जहाँ पर आपका फोटो रहता है ना, सभी Xerox copy, if you take off your Aadhaar card, normally the page is big, और Aadhaar card तो बीच में इतना छोटा सा रहता है. So sign it or write on it where your actual the material of the Aadhaar card is. Don't sign below.
Okay.
You get it?
And what is the reason for that?
Because you remember where you gave it. Kal ko that parcel is misused. You see that Xerox copy and then you are this to I had given in my hotel. You can tell the officer, sir, ये आदमी misuse कर रहा है, मैं नहीं.
Okay.
So at least
I hope they don't object. I hope they don't.
Why will they object? Why will they object? अरे why will they object?
Visibility नहीं आएगा. We want it for our purpose. आप नीचे sign करो.
Correct. No. You explain to them कि why it is susceptible to misuse. और मैं आपको मेरा identity है. अगर कोई आया तो मेरे घर से रूम में बैठा हूँ, मेरा original लो. No problem.
And then you said something that make sure that he destroys it. When should I ask him to destroy?
No, there is, if you take an extra copy, make sure it is done. But what you give to the hotel with your signature and what is written on it, absolutely no problem. So that tomorrow you can identify कि Xerox copy किसको दिए. आप समझे मेरी बात? Put a date on it. But ये date पे I was here, so you will know. You can go back in time and know.
Fine, got it.
Okay, buddy.
Wonderful lecture, sir. Great, sir.
Thank you so much. Thank you.
आज सर नींद नहीं आने वाली आधे लोग हुए यहाँ पे. They'll be on a red alert. कहाँ पे क्या papers.
You just have to be careful, Baba, because these things do happen. I'm telling you, it's very sorry to see people who are totally innocent and they'll be sitting here crying and then they get petrified of the fact that drugs, मेरे नाम से drug आ गया sir. You know, it's just very traumatic for any person to go through it. You know, so
right.
just being a little careful is always good.
Right, sir. I think we are almost around 8:30 and ma'am is staring at me for a very long time. So I'll give it to ma'am now. Ma'am, I think you have the access to mic.
Yes.
Thank you so much. I'll take your leave. Yeah?
Thank you so much, sir. Thank you for your time, sir.
Thank you, brother.
Enjoyed it.
Thank you, sir. In terms of the forensics, we'll be getting into it much later in the lectures after sir has completed the entire act thoroughly. So we really encourage you to join this. We're very privileged with the kind of knowledge, and I'm sure you've seen that in the webinar. You've seen the quantum of knowledge that you're going to gain. I think we're already overwhelmed with 2 webinars. Now just imagine what it's going to be like with the actual breaking down of the act bit by bit. So we look forward to a large number of participants in this program. Raghav.
Right. Guys, you've already, gone through 2 classes now. You know where this is heading, and most of you have already taken the forensics, the deconstruction, other courses that we have done on deconstruction. Those who have not, I have shared the link in the chat box. Check out POXO, check out evidence and forensics, and check out NDPS and go for them. It's a new stream of knowledge and it's going to help you. It's going to improve the kind of, how articulate your thoughts are on different kinds of laws. It takes you out of the matrimonial laws, civil, CPC, CRPC, everyone's doing that. But these are some special streams that no one's touched, and fortunately or unfortunately, there's a huge market there. And also try to share it with the people that you are in touch with and who might want to do it. And thank you so much. Just visit the site, visit the link, and enroll with us. We'll start from 24th May, and do let me know in the chat that how was the webinar. Thank you so much. Thank you so much, ma'am. Have a good evening, everyone.